Welcome friends. Today once again I am present before you on the issues of on the disciplinary proceedings. Today I would try to explain the issue on the one of the most important issues which emerges out of any disciplinary proceeding, and the issue is allegation of bias which a charged officer may have against the inquiry officer who has been appointed to undertake the oral inquiry under Rule 14 of the CCA Rules 1964. Friends, we all know fundamental principle of natural justice is that any decision making, whether in the disciplinary proceedings or for that matter in any other proceedings, should be conducted in a dispassionate and objective manner. That is, in a non-biased manner. If there is a bias where everything which is done subsequent to that becomes nullity in the eyes of law. Friends, in talking about in the context of the CCA Rule 1965, let me make one thing very clear that CCA Rule 1965 as such do not provide for raising of the plea of bias. But the DOPT in Office Memorandum 3940 70 dated 9th November 1972 does provide for raising of the plea and what is going to be the outcome of that plea which a charged officer may raise before the inquiry officer. This circular, which has got the power of the rule, provides that as soon as the plea of bias is raised, the inquiry needs to be stayed and the matter is required to be referred to the disciplinary authority for sorting out the issue. It means the moment the charge officer raises this plea, the inquiry officer has to put a quietus on the proceeding and he should await for the instructions of the disciplinary authority. Quite similar to the DOPT instruction, the CVC circular number 3 of 2024 dated 19 February 2024 provides, referring the circular issued by the Railway Board while reiterating this very circular of the DOPT, that this circular which has been issued by the Railway Board should be adopted by all the organizations concerned. And this circular issued by the CVC, which is in turn based on the Railway Board circular, this circular dated 19th February 2024 inter alia provides for the disclosure of reasons by the charged officer for bias post appointment of the inquiry officer. It says that the plea of bias should be raised as soon as the inquiry proceedings are commenced. Now, the question that arises, supposing a charged officer is not in a position to, he has not raised the plea of bias against the inquiry officer, the moment the inquiry officer was provided, can we say he is stopped from raising this plea subsequently? So, the rules are absolutely silent on this, and the humble understanding of me is that the plea of stage can be raised, though it would be preferable at the very start of the inquiry proceeding, but it can always be raised at any stage of the proceeding. Definitely, post conclusion of the inquiry proceeding, such a plea cannot be raised. If at all it is raised, it will not be entertained. Now, my suggestion to all the charged officers would be that the moment he gets a feeling, the moment he is able to gather material that the inquiry officer which has been appointed by the disciplinary authority has a bias, maybe because of his involvement in a similar matter at any stage of the proceedings, and maybe at the preliminary stage, or maybe subsequently, such a plea should be raised. The bias which the inquiry officer may harbor maybe can be understood the way the proceedings are being undertaken. If the charged officer is able to conclude that the conclusion which the inquiry officer has is going to take in the inquiry is foregone. Maybe because he is not allowing the charge officer to raise pleas, maybe he is not allowing the charge officer to introduce documentary evidences in his support, maybe he is not being allowed by the inquiry officer to adduce evidences, maybe he is not allowing the charge officer to inspect the records, maybe he is not allowing the charge officer to raise certain questions to the witnesses which have been introduced by the disciplinary authority. One can safely conclude that there is an inherent bias in the minds of the inquiry officer. So my suggestion in such circumstances would be that the charge officer should immediately move an application to the inquiry officer with a copy to the disciplinary authority, or maybe the vice versa, raising the allegation of bias. Maybe the disciplinary authority say the plea is without any substance, assuming the charge officer has a very firm belief that the inquiry officer is biased and the inquiry goes against him. Such a plea can definitely be raised in the court of law. So such is the importance of the raising of the plea of bias, and entire proceedings will become in nullity. In case the charge officer is able to demonstrate with the appellate authority, maybe in the court of law, that there was a bias and he is able to show the reasons for that, then the inquiry will get vitiated and maybe the fresh inquiry might be held, which might ultimately go in favor of the in charge officer. So please, friends, my suggestion to the charge officer would be that in case they harbor a feeling of bias against the inquiry officer, don't hesitate in raising that plea, maybe in the midst of the inquiry. And believe me, such a plea may be of tremendous help at the subsequent day. This is what, in fact, I wanted to share with you today, and I hope you understand what I am trying to convey. And in case you like the video, if you like the input, kindly share with others. Maybe if you know you are not getting benefit, maybe others might get benefit. With this pious hope, I thank you for joining me. Thank you.